Welcome to the Prison Professors Podcast. We serve people who face challenges with prosecution, sentencing, and prison. My co-founders are Sean Hopwood and Justin Paperny. My name is Michael Santos. We create digital content and our team offers individual consulting services. We also assist agencies that want to improve outcomes. To learn how we can help you, text the word PrisonPro to 44222. Again, text PrisonPro to 44222 and get our free brochure. You can also visit us at prisonprofessors.com or contact Justin at 818-424-2220. Please subscribe to our podcast on iTunes. Send confirmation that you have rated our Prison Professors podcast and leave us a review, and we'll send you a free digital book. We'll work hard to earn 5 stars. Stay tuned for a 20 to 30-minute episode with Prison Professors. I am Michael Santos, and I want to welcome you to another Prison Professors podcast episode. Earlier episodes provided you with the background information on my partners and me. Today we're recording a series of 5 podcasts that will help our listeners understand a bit more about the process of going into the criminal justice system. Now, as of now, I have 5 episodes planned. They include the following. Number 1, understanding the process. That's what I'll be discussing today. Number 2, understanding the stakeholders. That's what I'll be discussing in the next podcast. Number 3, understanding the custody and classification system. Number 4, how to prepare for prison. And 5, why writing a narrative can assist you through the journey. Now, it's important that anybody going into the system has some grasp of knowledge regarding what they're going to expect. Because the more we understand, the more we know about it, the more effective we can become at building a path or architecting a strategy that's going to lead us to success. Now, we're going to start in this Understanding the Process episode with really just some basic understanding of what you're going to find in the future. So we're going to start by paraphrasing Stephen Covey. Now, he was a mentor of mine when I began serving my sentence. I considered many people that I've read, many authors that I read their books, they were mentors of mine. But in Stephen Covey's timeless bestseller, The 7 Habits of Highly Effective People, Dr. Covey advised that we should try to understand before we try to be understood. Now, he's an inspiring guy to me because what he did is study people who were successful in various industries at various times in history, and he discovered that all of those people who became highly successful, they had 7 habits. One of those habits was always to begin with this concept of I want to understand where I am and what I'm doing and where I'm going before I try and get other people to understand me. And that guidance applies to anyone who is about to go into the prison system. If you want to master prison, you really have to understand it before you go inside. So we are recording this series of episodes of the Prison Professors Podcast specifically for people who anticipate that they may be going into the criminal justice system. Those who have a solid understanding of the system or who are looking for more engaging interviews like the ones that we have done with Scott Tucker, a billionaire going to prison, or one that we have done with my partners, Sean Hopwood or Justin Paperny, you may want to skip this episode if you already know what you're looking for. But if you think that you may be going into the system, you really want to pay attention to this very simple series. Our goal is to help listeners make decisions that will put them on the path for the best possible outcome. And the best possible outcome always requires good decisions. But to make good decisions going forward, we definitely need to understand how the process works. So let's begin with some instructions that someone going into the criminal justice system may want to follow. And those instructions begin with understand everybody you're going to encounter. So somebody goes into the system when the investigation begins. So the investigators, they are the ones who start the whole process. Those investigators may work as part of the SEC, the Securities and Exchange Commission, the IRS, the Internal Revenue Service, the FBI, or the DEA, or any other agency. There are so many thousands of federal crimes that prosecutors can bring against somebody, but those prosecutions always begin with an investigation. So the allegations of misconduct can start the investigation, and during that investigation phase, agents will collect evidence. They will work closely with federal prosecutors. The federal prosecutors will make a decision on how to proceed. If they want to charge a person with a crime, they have different options on how they are going to bring those charges. But once investigators and prosecutors decide to bring charges, especially in the federal system, the person becomes a defendant. And that's when things really begin to change. That's when the charge happens, right? The criminal charge. When prosecutors choose to bring a case against someone, chances for a conviction become exceedingly high. At first, the person may be a target of an investigation. The investigation can take place secretly with a grand jury. In the grand jury proceeding, a prosecutor puts together a group of citizens. Those citizens listen to evidence that the prosecutor presents. Now, that evidence can include live testimony from investigators and live testimony from other witnesses. The members of the grand jury will listen to the witnesses as they respond to leading questions from the prosecutor. And at some point, the prosecutor is going to ask members of the grand jury to indict the target of the investigation. Now, in some cases, prosecutors may use a less formal way of charging people. Rather than going through a grand jury, they may file a criminal information. Now, the criminal information can result from an agreement that the prosecutor makes with the defense team. But regardless of how prosecutors bring charges, whether it's through a criminal indictment or through a criminal information, things will change. To start, as I said earlier, a person then becomes a defendant once the charges are brought. Now, we have all heard stories that in our country, we have a presumption of innocence. Yet few people who have been charged with a federal crime recognize that distinction. Once you're charged and you're a defendant in federal court, the chances are more than 90% that a sentencing hearing will eventually follow. Statistics show those consequences, and we encourage our listeners to do their own research. Simply type into Google United States Attorney's Annual Statistical Report, or download it from our website at prisonprofessors.com. Read the data. That data is going to show how frequently convictions follow after a criminal charge. So it'll help, the more you understand about that system, for individuals who are going into it, the more individuals can make better decisions as they advance through the process. At our website, prisonprofessors.com, we offer an abundance of articles, blogs, and videos that will help people understand more about the criminal justice system. Learn as much as possible. We don't give legal advice, but we provide a lot of content that will help our audience who are going into the system, our audience members who are going into the system. We want to help them make better decisions. We want them to have great outcomes. And that's why it's so crucial to educate yourself on what's coming. Our co-founder, Sean Hopwood, is a lawyer, but he doesn't use our site to provide legal advice. To participate in litigation, Sean would need all types of details about the case. Details of a case require many hours of research, hundreds, sometimes thousands of hours, and time comes at a premium. So we trust that our listeners will have a solid legal team in place to advise them. But we offer all types of information through our Prison Professors podcast, through our YouTube channel, through our Facebook page, through our website that will give them supplemental information that they can take into consideration as they encounter this very difficult challenge. Now, on the other hand, members of our audience, we want them to understand the costs that come with every decision. Those who want to master prison quickly should realize implications of every decision along the way. We always make better decisions when we have a more complete understanding of the process. And that was the essence of Stephen Covey's message. Seek to understand before you seek to be understood. So what comes after the charge? Well, once prosecutors charge a person, the defendant will need a defense attorney. And if a client does not have the resources to hire a defense attorney, then the court will provide an attorney. And the court-appointed attorney may be a part of the federal defenders, or the court-appointed attorney may be a defense attorney that agrees to work on the CJA panel. Every federal judicial district has a roster of attorneys who are experienced in federal court. And if you don't know, which attorneys to turn to, we can give you a free resource just to take a look. Go to our website at prisonprofessors.com, click on our directory map of attorneys, and you will see in every judicial district a few. We don't provide a massive number of attorneys. We just provide 10 to 12 attorneys from each district that we have vetted and we know have experience in practicing in federal courts. Now, regardless of whether the defense attorney serves on the panel or with the federal defenders, that person will have been exposed to extensive amounts of training and resources. Federal defenders and panel attorneys are well qualified to represent defendants in federal court, but the defendant can do some work that will help ease the process of preparing for the journey ahead. Now, other defendants may retain counsel. Attorneys who have extensive practice in federal court, keep in mind, charge a premium. Hourly fees for defense attorneys with experience in federal court, depending upon how long the attorney has been practicing and the geographical locations, can start at $400, $500, $600 an hour. We know some attorneys with whom we have worked that charge more than $1,500 an hour. So defendants should expect to spend tens of thousands of dollars for any type of representation in federal court. A typical guilty plea here in Southern California with a skilled federal attorney who's got practices in federal court probably begins in the $50,000 range at the start of 2018. So for those who lack access to capital, we really urge defendants to use federal defenders rather than hire an attorney who lacks experience in federal court, because sentencing is a very specialized niche. And if an individual doesn't have experience, you don't really want to be trying with somebody who doesn't know what he's doing in federal court. So I have a lot of respect for federal defenders, people on the CJA panel, but I also encourage defendants to work to help themselves. Now, our team, we have a process for vetting defense attorneys in federal court, as I said above, and we also offer consulting services to assist defendants who need that guidance, because it's really important to put a lot of energy and time in assessing whether you have the right defense attorney, because that defense attorney is going to be the quarterback of your team. So we really encourage you to choose wisely. So after you've been charged and after you have a defense attorney, the next step in the process is going to be the plea. So if prosecutors bring charges against a defendant, a plea hearing is going to follow at some point. And that plea hearing can happen quickly or it can be postponed, particularly for people who may be cooperating. Now, we work with some defendants who may wait for years before they actually face the criminal charge and enter a plea. But in most cases, people start the process early with a not guilty plea in a hearing. Then, after the defense attorneys work out the most favorable deal, the defendants will change their plea to guilty in accordance with the plea agreement. And we'll talk a little bit about pleading guilty. You see, entering a guilty plea is a formal proceeding. There's not going to be much conversation during that plea hearing. Early in the hearing, the defense attorney will let the judge know that the defendant wants to enter a plea or change of plea, and the judge will then ask the defendant to rise. The defendant must swear to tell the truth under penalty of perjury, and the judge will let the defendant know that he is not bound by any deal that the prosecutor may have made. The judge can do whatever he wants in these places. He can accept the guilty plea, or he can reject the guilty plea. So the defendant must acknowledge that he understands what's going on. And after the judge is satisfied that the defendant understands, the judge is going to read each criminal charge. Then the judge will ask the defendant if he is guilty of the charge. The defendant will not have an opportunity to explain or elaborate. He will simply say, "I plead guilty." Opportunities for explanations and elaborations will come much later. And those are really important. Now, pleading not guilty is another option. If the defendant persists with a not guilty plea, a trial is going to follow in most cases. Unless you have some type of an exceptional case and exceptional legal counsel, the case will proceed to a trial. It would be very rare for the Department of Justice to drop a case. I'm not going to say it doesn't happen. It has happened. It happened in the case, I remember a case against a fella down here who was one of the executives of the Broadcom Corporation, and he was trying to negotiate a plea providing the government with a substantial forfeiture and pleading guilty in exchange for a limited amount of time in prison. But the judge rejected the plea. Well, proceedings continued. The prosecution was successful in showing, the defense attorney was successful in showing that the prosecutors had abused their power, and the judge threw the case out. So it can happen that a trial doesn't follow. But make sure that you understand the particulars of your case, you've got a good team, and you're making good decisions along the way. Because the trial can be a very expensive, time-consuming process. It can last for weeks, months, and during the trial, prosecutors are going to present evidence. Now, the defense attorney will argue to discredit that evidence, but the judge is going to decide what evidence the jury will hear. And in time, the jury is going to render a verdict. If the verdict is not guilty, well, the judge will release the defendant right there and he can go home, in most cases. If the verdict is guilty, on the other hand, the process will continue with a pre-sentence investigation. And understand that individuals who exercise their right to go to trial ordinarily face a sentence that is going to be much more severe than individuals who enter into a plea agreement. So again, we're not dispensing legal advice. We're just recommending, learn as much as you can. Learn about people who have gone through the system. Learn from the story of Scott Tucker, who chose to go to trial and was convicted by a jury. And now prosecutors are asking for the judge to impose a sentence in excess of 100 years. 100 years in federal prison. Now, I doubt he's going to get that much time, but when you have factors such as the amount of loss being taken into consideration, and when probation officers and prosecutors can argue that the defendant doesn't show remorse, well, the sentence can be really, really tough. And so we just encourage people, seek to understand before you seek to be understood. And if you have any questions on that, I really urge you, read as many articles as you possibly can, watch as many videos as you can, listen to podcasts, listen to people, and take all of that information into your calculus as you're making that very important decision of whether to go to trial or whether to try and plead guilty to a term that might be consistent with a plea agreement offering more leniency. So after there is a verdict of guilt, whether it is by a plea or whether it is by a conviction at trial, the next step is going to be a pre-sentence investigation. What does that mean? It's sometimes known as the PSI or the PSR. But a federal probation officer will begin the pre-sentence investigation by reviewing a report from the federal prosecutor. Now, the prosecutor's report will present the government's version of events. Probation officers will cut and paste the prosecutor's version of events into a report that is known as the pre-sentence investigation report. Again, also abbreviated as the PSR. Now, to continue the investigation, the probation officer will speak with the defendant. And the defense attorney should be present during the PSI interview. If a defense attorney chooses not to prepare the defendant for the PSI, well, the defendant will have a red flag. He's probably not being advised appropriately. Defendants should take every effort to prepare for the PSI, as it will have lasting implications. Those implications stick around long after the sentencing hearing. During the pre-sentence investigation interview, the probation officer will ask the defendant about what he or she has to say about the offense. We advise defendants to prepare for this question. Ideally, the defendant will have written a narrative in advance of the pre-sentence investigation. And the defendant can explain the process of thinking that went into his life before he got involved in this crime through the content that he provides in that narrative. So according to video interviews that our team has done with federal judges, and those interviews are available on our YouTube channel, that pre-sentence investigation report can have an enormous influence at sentencing. Further, it will have an influence on placement in the Bureau of Prisons. So the pre-sentence investigation report will influence the journey in prison, it will influence when the defendant transfers back into the community, and it will influence the level of liberty the defendant has while he is on supervised release. For those reasons, we really urge defendants to take every opportunity to understand the pre-sentence investigation and to prepare. Fortune, as you know, always favors those who prepare. Now, the probation officer will conclude the investigation with an extensive pre-sentence investigation report. That's the PSR. And the PSR will include what the probation officer learned from the defendant and also from other people who are related to the defendant. That may include family members, it may include employers, it may include creditors, it may include victims. So the PSR will include both objective and subjective information. The objective information includes information about the conviction. That conviction is going to follow in line with a statute that Congress passed and that the president signed into law. It will also include information that will influence the federal sentencing guidelines. Those federal sentencing guidelines are complex. So we urge defendants, learn about how various factors can influence those guidelines. Also, it is crucial for defendants to know how they can work to get the most favorable outcome during the sentencing hearing. It all starts with the pre-sentence investigation report. So make sure, if you are facing a proceeding in federal court, make sure that you learn about the pre-sentence investigation report. Make sure that you've done everything that is within your power to influence a favorable pre-sentence investigation report. That can be the first step, not only to influencing a mercy at sentencing, but it can also influence the journey that you have through the Bureau of Prisons. It can influence what programs you're able to participate in the Bureau of Prisons. It can influence whether you qualify for potential early release in programs that the Bureau of Prisons offers. It can influence what level of liberty you're going to have when you come home. And, it can influence even whether you are going to be a good candidate for early termination of supervised release. So after the pre-sentence investigation report is complete, the next step in the process is going to be the all-important sentencing hearing. Learn and understand about sentencing hearings before the inevitable date. Unfortunately, when prosecutors bring charges, more than 80% of the defendants face a sentencing hearing. Influencing the outcome with a well-thought-out sentence mitigation strategy is essential. Learn what steps you can take today to move the needle in your direction. Although every case is different and requires a highly customized approach, we can provide some bullet point suggestions. And those suggestions are available on our website at prisonprofessors.com. But let me just throw some out for you to be thinking of if you're just driving down the road listening to this podcast. Think about the perspective of all stakeholders. Their perception is much more important than your perception. So learn more about the stakeholders in the following chapter. So the next episode on Prison Professors, we're going to discuss those stakeholders, and I encourage you to tune in. Number 2, think about the victims of the crime. If you don't think that your crime has a victim, then you're not thinking about the stakeholders' perception. From the stakeholders' perception, the crime has victims, period. But who are they? How have they suffered? What can you say about them? You got to take all of this into your calculus as you're preparing for that sentencing hearing. Now, prepare to reveal, this is number 3, prepare to reveal what you have learned from the process. In what ways have you grown as a result of this entire process from start to finish? What have you thought about? What have you learned? What have you done to make things better? So number 4, execute a plan that is going to differentiate you from every other defendant that goes before a sentencing hearing. What is the judge's perception? And what can you do to influence that perception? Number 5, influence the process by showing what steps you have taken to make things right. This is not rocket science. You just got to figure out, hey, if you've been convicted of a crime, you've done something wrong in the eyes of the system. What are you doing to make things right? Our podcasts will show you what other people have done. But more importantly, what are you doing? Number 6, help the judge understand how you will adjust your life in light of this experience. And finally, number 7, convince the judge that you will never, ever appear as a criminal defendant in any court again. If you keep those 7 points in mind, you've got a long ways toward preparing for the sentencing hearing. The next step after you have been sentenced is designation in the Bureau of Prisons. Well, I guess if imprisonment has been imposed as part of the sanction. Now, in some cases, a comprehensive strategy will result in an alternative sanction that does not include time in custody. Our team at Prison Professors does its best to help defendants who want to advance arguments for a non-custodial sentence. And we've been successful. We'd be happy to connect you with some people that have avoided time in prison when they walked into this thinking that they could very well serve many years in prison. But no one can change the past. All we can do is sow seeds for a better future. And that's what you've got to do. Start sowing seeds for a better future. Unfortunately, though, in most cases, federal sentences include prison. And when prison becomes a part of the journey, the next step after the sentencing hearing will be for the Bureau of Prisons to assign the appropriate prison. Several factors go into the equation of prison designations. Now, those are objective factors. The Bureau of Prisons relies upon the latest edition of Program Statement 5100, which as of today is 5100.08, to determine prison designations. And in a future episode, we'll talk about those. The complicated matrix assigns points to objective factors that include criminal history, type of offense, severity of crime, and so forth. And a variance table makes additional adjustments. Public safety factors and management variables can also influence the custody and classification system. Our website includes a calculator that will help you calculate the point system. So look for it on the Prison Professor's website if you want to find out how the Bureau of Prisons is going to classify you. Besides custody and classification scoring, the Bureau of Prisons will also consider judicial recommendations, medical needs, prison population levels, institutional needs, and geographical locations. All of those factors go into the consideration of where the Bureau of Prisons will determine to send a defendant. Then the BOP will put the prisoner in the appropriate prison or allow him to surrender there voluntarily. Defendants should learn everything they can about the designation process, because the more they understand, the better prepared they will be to influence where they will serve their time. And I can tell you, not all prisons are equal. Although we can master any environment, the earlier we get started in mastering the process, the better off we are. Isn't that always the case in life? Now, serving the sentence. Success through any prison journey begins with a very clear understanding. When we can define what success looks like on the other side of the journey, we have a starting point. The heart of all of our episodes will describe how to take us from where we are today to the life that we want to create. Although many of us would like to change the past, we master the system when we deal with the world as it exists, rather than as we would like it to be. Our team at prisonprofessors.com will help you every step of the way. We're 100% authentic, and we just want to share as much information as we can, and we just hope you find value in it. So that's it for this episode. I am Michael Santos with prisonprofessors.com. On behalf of my two partners, Justin Paperny and Sean Hopwood, we want to thank you for listening. Tune in. Make sure that you subscribe to the show. We hope that you will rate and review the show, because that helps us get more distribution on iTunes. And if you want more information, please text the word Prison Pro to 44222. That's text Prison Pro to 44222. And you will get an automatic response of a booklet that we prepared that shows the various ways that we help people. Again, text Prison Pro to 44222. And if you haven't subscribed yet, please subscribe to our podcast, rate and review the show. Visit us on YouTube, Facebook, just anywhere that you look for your social media. We are there. Again, thanks again. Back tomorrow with another inspiring episode from Prison Professors.